Welcome to our final module. I'm so proud of you that you've made it throughout this journey throughout the semester rather. And here we are, we're in our final module, which really focuses on other specialized topics in the criminal justice system. Now, this module really is a catch-all. In other words, we know the three primary components of the criminal justice system are law enforcement, the courts, and corrections. However, the way the individuals wrote the book that I use, and again, you didn't need the book. They end the semester looking at other avenues of the criminal justice system, and these are topics that typically have their own specialized courses. So the first of which is juvenile justice, or the juvenile justice system, and then in our final chapter for the semester, we'll look at some other specialized topics. We'll talk about terrorism, talk about, a little bit of victimology, violence on campus, the CSI effect. In my homicide class, I talk about that. But with this being said, let's go ahead and jump right into the juvenile justice system, shall we? Here in chapter 13. So a question I wanted you to ponder, and this will be a great topic in class, are do boot camps work? Do boot camps work? And the answer in a loud, resounding discussion is no. Boot camps typically do not work. The reason why they don't work is because the intended consequence is not what the juvenile justice system was devised to be. The other thing about boot camps are that it's a temporary fix. It's a temporary fix for a major gaping problem. And there's videos out there, and you'll see it within the lecture, of course. But boot camps, other scared straight programs, they don't work. They do not work. Juveniles or young people or young adults or youngsters, whatever you want to call them, kids, they're not afraid of a person who is a drill sergeant or a military person or an inmate, because they know that I'm just going through this right now in this moment, but at any point I'm going to be done and I'm going to get to go back home. So very loudly and clearly, boot camps do not work. So we got to talk about what the juvenile justice system was supposed to be, right? The contemporary juvenile justice system was built in part based on a common sense approach that youth need protection and understanding. So the idea, as we look at our brief history of the juvenile justice system, is that children were in need of protection. They also needed to be understood because historically children were not treated as children. In fact, and I talk about this in my I have a juvenile justice class, but in juvenile justice, children are actually seen as nothing more than property. Could you imagine? All of us were children at some point. Could you imagine being seen as nothing more than property? Your parents viewed you as property. The outside world viewed you as property. That's how children were made to feel, and that was the understanding behind children. So the juvenile justice system is very distinct from the adult criminal justice system in that it has its own special terms and procedures. And unlike the adult system, the goal of the juvenile justice system is to rehabilitate. This is very important, whereas the adult system is more punitive based. So simply put, when you hear the term rehabilitative, when you hear the term rehabilitate, all that simply means is that the juvenile justice system is designed to rehabilitate or treat a young person as if they're sick. That's all it is. It's designed to treat a young person as if they're sick. And this is very, very important. The adult criminal justice system is more punitive. In other words, in this case, the adult system is designed to punish individuals who break the law. So that's one of the things I want to give you as a distinction, even though this is an intro class. Juvenile justice system, rehabilitate. Rehabilitate means that the juvenile or the young person is sick. We want to treat them as they're sick. We want to help them get better. The adult system, no, you're an adult. You know right from wrong. We're not here to make you better. We're here to punish you for your actions, okay? So that's two very important distinct features that I want you to take away from this course. Juvenile justice system, rehabilitate, treat. Adult system, punitive, punish. So I want you to think about this question. If you have a 7 or 8-year-old and they were to go ahead and whack their sibling, would they have a different understanding of that act compared to a 23-year-old who maybe takes out their sibling? The answer is absolutely yes, because scientifically, we know that a child's brain is still developing. They can't comprehend rational decisions compared to someone in their 20s or 30s. In fact, the vast majority of the students that I've had over the years, now there have been places that I've made stops at that I've had students that were much older. I've had students that were much older than me, way older than me. But generally speaking, the vast majority of the time, the students that I have lectured to are well under 25. They're, 18, 19, 20 years old, 21 maybe if they're graduating, but they're well under 25. So I like to joke in class and say, hey, for every one of you sitting in my classroom, while you know right from wrong, understand your brain is not fully developed. In fact, it won't reach that peak until the age of 25. And that's the vast majority of who I'm talking to. So a 7 or 8-year-old who were to go ahead and whack or off their sibling, in this case, they're not going to have a full understanding of what they did compared to a 23-year-old who may do the same thing, or 24 or 25. Now, I don't want the 24-year-old or the 23-year-old to say, oh, Professor Fields, you told me my brain's not fully developed, so I shouldn't be held accountable. Absolutely not. That's not what that's saying. You will be held accountable if you're 20, 21, 22, 23, and you take out your sibling. But if you're 7 or 8 years old and it's accidental, you don't know, you saw something in the TV or the video game, that child does not have a full understanding of, or they have not reached the full understanding of this quote unquote age of reason, so to speak. So reform started in 1899, and that was with the creation of juvenile courts. So the first juvenile court was created in Cook County, Illinois in 1899. This is essentially the birth of the juvenile justice system. Right now, obviously, the juvenile justice system has changed over the years, but we can go back to Cook County, Illinois in 1899 as the catalyst for the creation of the system. So juvenile courts are courts designed specifically for juveniles to regulate the treatment and control of dependent, neglected, and delinquent children. So you'll hear this term again, neglected children, delinquent children, even dependent children for that matter. But it's a specialty court. It's a special court. And part of why it was created as such is because the adult criminal justice system back before 1899 held hearings dealing with juvenile related matters. So a young person was treated almost the same way as an adult, which is really scary to think about in today's day and age, simply because we know that there is the separation between the two courts, the adult system, the juvenile system, adult court, juvenile court. So by 1945, all states implemented some type of juvenile court, and it was based on this medical model, which is treatment, which focuses on rehabilitation over punishment. Again, biggest difference between juvenile court, juvenile justice system, and adult criminal justice system is that the juvenile system focuses on treatment, rehabilitation, its medical model. The adult system focuses on punishment. It's punitive based. So I just want to put up a few different terms and definitions in the what it means in the juvenile justice system and what it means in the criminal justice or adult system. And I'm not going to really go through all of these. I just want to point out a couple. For example, when we think about someone committing a delinquent act, in the juvenile system, they'll say, do you understand you committed a delinquent act? And you go, yes, sir. What they're saying is, do you understand that you've committed a crime? But in juvenile court, we say delinquent act. In the juvenile justice system, we say delinquent act. In the adult system, we're just going to say straight up, you committed the crime of robbery. You committed the crime of theft. Whereas in the juvenile court is you've committed the delinquent act of robbery, or you've committed the delinquent act of theft. So there's the difference between the two. When we look at a delinquent, that's just a juvenile who's been adjudicated of a delinquent act. They're a criminal. If they're going to be detained or locked up, they'll go to what's called a detention center. That's just another term for jail. If they've been sentenced, they'll go to what's called disposition. But it's different. In juvenile court, you'll say we're going to proceed to disposition. In adult court, we'll say we're going to proceed to sentencing. Okay, so again, two different terminologies. It means the same thing, but it's one thing in one system and something else in a totally different system. And then lastly, we look at just some of the other key terms. For example, filing a petition is the equivalent of an information or an indictment. If you want to go get a warrant on a juvenile, you don't say, Judge, can you sign a warrant? The judge is going to look at you funny. You're going to say, Judge, can you sign an order to take into custody, or a pickup order, a PUO or an OTTIC? And everyone knows what an order to take into custody or pickup order means. That means a warrant. So let's talk about the contemporary juvenile justice system, shall we? We did spend a moment looking at the classical or historical context of the juvenile justice system, but we can come back and look at contemporary juvenile justice. So youthful offenders are typically those offenders who are 18 years or younger. Now, some would argue we shouldn't count an 18-year-old because an 18-year-old is an adult. But most people will say if you're under the age of an adult, under the age of 18, you are a juvenile. In other words, when you turn 18, you're an adult. So 3 states in the country in which the age to be charged as an adult is 17 or older. Again, out of our 50 states, we have 3 states where at 17 you are classified as an adult. It's controversial, but it is the law. Do you live in any one of these states? Well, I'll tell you what, I live in one of them. So Georgia, Texas, and Wisconsin are the only 3 states in the country where if you are 17 years old, you are classified as an adult. If you break the law or you commit a criminal offense, you will go to jail and you will go to adult court, period. If you're a 17-year-old and you're visiting Florida or you're visiting North Carolina or you're visiting Oklahoma or you're visiting, Idaho, whatever, any state that borders these 3 states, and you commit an offense, you will go to juvenile delinquency court because you would have committed a delinquent act. But if you are in Georgia, Texas, Wisconsin, and you commit what you believe was a delinquent act, the law is not going to say it's a delinquent act. The law is going to say you committed a criminal act, and you can and may often go to jail for the commission of that act. So yes, juvenile courts typically may supervise young adults until 20 or till up to the 24th birthday. Georgia, this can occur under certain circumstances. Most of the time, a person can be supervised well beyond the point of them becoming an adult if they owe restitution. The courts typically won't let anyone off the hook, even if they're 20, 21, 22, if they owe restitution. And the argument is, hey, if you have money to buy drugs or money to buy whatever, you should have money to pay back your restitution. So don't linger on this and expect the court to dismiss it. The courts never do that. So that's why you can have someone being 20, 21, 22, 23 that's still under supervision because they owe restitution. So there's 2 types of juvenile courts, right? We have delinquency court. Delinquency court courts can hold jurisdiction throughout, regardless of age. This is the juvenile court that may hold jurisdiction over criminal matters. And these are criminal matters that were committed during the time that the offender was considered a juvenile delinquent. It could be illegal actions. It can include SHINs, child in need of services, and it can also include status offenses. These are offenses that apply strictly to juveniles, but if an adult does them, they're not going to get in trouble. An adult's not going to get in trouble for skipping work or skipping school. Now, the adult may get in trouble and may lose their job, or may have a poor grade, but they're not generally going to get in trouble as a juvenile would if they're skipping school, right? And saying they don't want to go to school. Same thing goes for if they smoke or if they are, what's considered ungovernable. In other words, you can't control their actions or they violate curfew. So that is delinquency court. Now, the other side of this is dependency court. And dependency court is a type of juvenile court that deals with family matters, particularly child neglect and endangerment, custodial issues, and foster or adoption issues. So with dependency court, typically there has to be negligent parents or a pattern of negligence exhibited from the parents, and that's why the state is going to cause them to lose custody of their children or come in and take their children. And so neglect is just simply put not providing basic necessities for a child. These necessities can be food, clothing, shelter, and even love. So somewhere along the lines, a child was, dealing with neglect. They were not receiving food or adequate shelter or adequate love. And so they are filed as, neglect. When this happens, typically it's possible for the child to be removed from their parents' home and placed in foster care. At that point, they'll go to one or two, they'll typically go through what's called a TPR, or termination of parental rights, and they may have a case plan that they may have to work for 6 months before they can be reunited with their children. It is a lengthy process, folks. You don't want to get your child protective services, whatever state you're in, you don't want to get them involved, because if you do, it takes a long time to get your children back. It is quite the task. So policing juveniles, that's kind of where my come in to play through two hats. I'm going to really get to the second hat. But usually law enforcement is the first point of contact in the criminal justice or juvenile justice system. With juveniles, there creates many challenges. For example, are we going to start taking juveniles to the station and release to their parents if they've committed a minor offense? Or are we going to just hold them and wait till their parents can get to whatever destination they're at? Law enforcement officers can also make referrals to juvenile court, although it's very, very rare. Typically, when law enforcement interacts with people in the probation office, it's because they've seen them walking through my neighborhood or walking around, and so they use that as a targeted location. So that's all. I just wanted you to understand understand that, so to speak, as it relates to law enforcement and how they may sometimes interact with juveniles, so to speak. But again, if they don't feel like they have enough probable cause to take the juvenile into custody, then they can make a referral to juvenile court. It is very rare, though, but they can certainly do that. Now, of course, racial disparities exist. We do have to talk about it. We understand and know that, for black juveniles, the data shows there are detained at a higher rate than white, Hispanic, and even Asian juveniles. Law enforcement detection efforts usually focus on minority neighborhoods and minorities in general. That'll create what's called implicit bias. In other words, law enforcement will have the belief that the kids in this particular neighborhood or the kids in this particular subdivision or hood or project or whatever are going to act a certain kind of way. They're not going to have any disrespect for law enforcement. They're going to be mouthy. They're going to talk back. And it's unfortunate because when implicit bias starts, it's hard to get rid of it. It's really hard for an officer to say, you know what, I'm wrong. I'm wrong about this little black boy that you see shaking her hand. He's not a threat to me. But for some, they don't care. They're going to say, nope, I am, that's a threat. So implicit bias is real, and it can go on both sides. You can have individuals in the community who just don't trust the police. They don't care that this officer, put her hand out and was shaking this young boy's hand. They could care less. They just see her as another police officer, and therefore she must be up to no good. So what are the factors that help a relationship between officers and juveniles? Well, for some, basically, there's a belief that youth show complete disrespect for authority. There's the idea that having those cultural differences can also lead to that disrespect and mistrust. When looking at hostility or aggression, juveniles who are a little bit more angry and fired up are more likely to be taken into custody. So one way to build the bridge and try to close the gap is to utilize your school resource officers. Now, in a place like where I'm from, Gwinnett County, a metro suburb of Atlanta, we have what's called Gwinnett County Schools Police. So we don't have to put our school resource officers, through the ringer with learning how, or we wouldn't have to put school resource officers like from a police station through the ringer for them to learn how to be in schools. Instead, the Gwinnett County Public Schools, they have their own police force, they handle their own training, and you don't have to take away from a police agency who's trying to put forth officers to keep the schools safe. So big pro to having an SRO is that, of course, it provides safety in school. It can bridge the gap between youth and police. It can help the youth understand that I can go talk to this police officer and he's okay, she's okay. But the con is that it can create a negative atmosphere. How do you feel? And if you're listening to my lecture, did you remember your school resource officer? Did you remember seeing a cop at your school? Maybe you did, maybe you didn't. Did it make you uncomfortable knowing that this random officer or this officer that's been here from the beginning of the year, he's roaming the hall, she's roaming the hall, and what if something pops off? She might start spraying, she might start grabbing people. Like, we don't know. So for some, there's the feeling that having police officers in the school can result in more minor arrests and minor disciplinary action that otherwise would have been taken care of separately, so to speak. Now, with having police officers in the school, do school administrators believe that this is the viable answer if a student acts up? Hey, I'm gonna go ahead and get the police officer in here so he can take you to jail. That's very harmful and disingenuous when it comes to students who are in schools where SROs do operate. So a couple of programs that were out there, these programs tried to keep kids on the right path. They were real major fails. Drug abuse resistance education, DARE, school-based program designed to encourage youth to avoid drugs. Does it work? No, because when the youth is faced with the temptation of joining or actually using drugs, he might think of the catchy DARE song. It's like DARE to keep kids off drugs, and it's very catchy. But I guarantee you that's only going to get them so far, because these gangs and these gang members are ruthless. Speaking of gangs, if you have someone who is tasked with trying drugs and he's trying to remember DARE, he may be peer pressured by gang members. Well, a program to deal with gangs is called GREAT, Gang Resistance Education and Training, and it's a police program in which officers go to schools and educate the youth on the dangers of gangs. Does it work? Yeah, mostly not. It might work a little bit, but generally speaking, when you take these kids and you put them in DARE or GREAT, they are doing fantastic when they have someone else, or, they are, they're able to kind of comprehend what these programs mean and how beneficial these programs are. But at the end of the day, it only works while the police are there and the police are present and the student is present. It doesn't work the second they get back into the community. The officer's not going to be standing near you when somebody says, hey, do you want to buy these drugs? He's not going to be standing near you when someone is like, here's $500. What are you going to do to join this gang? So that's why these programs are great, but do they work? Not quite. So let's talk about court. Juvenile justice process roughly mirrors the adult system, but it takes a more informal path. Now, all the key players still exist. You get the judge, you get the prosecutor, you get the defense attorney. Probation officers are present as well. So for me, I thought I would go ahead and pull out my old badge. So this is my old badge when I was a probation officer. Look, even got you the name tag. You can see the name tag. So when I was in juvenile court, and this was given to me as a keepsake. I did not quite 5 years there. I think I did about maybe about almost 4. But we had gotten new badges too, because we had a rebranding. So instead of calling ourselves juvenile court, we called ourselves child advocacy and juvenile services. So they had to go ahead and change up the badge. They had to change up the ID card. And so I was like, well, here you go. And they was like, no, keep it. Have that be a memory from your time as a probation officer. But probation officers are key players in the juvenile court process, because remember what I talked about the other week. The probation officer is the fact finder of the judge. In fact, he's the arm of the court. And when you're a probation officer, you are tasked with, again, taking this oath. This is actually my oath for probation officer in juvenile court. I actually could not find this. And then I did some digging and I was like, oh, I found it. And, just to kind of give you a summation, it says, I, DeAndre Fields, do solemnly swear or affirm that I will faithfully and impartially discharge and perform all the duties incumbent upon me as a probation officer of the Juvenile Court of the Gwinnett Circuit, according to the best of my ability and understanding, and according to the laws and the Constitution of the state and the Constitution of the United States. And then it goes on and on. But of course, I had to sign it. So you can see there is my signature, and there is the judge's signature right there. And I signed that December 2nd, 2019. So probation officers are a key player in the juvenile court system, in addition to the judge, the prosecutor, and the defense attorney. So when a juvenile or a young person goes to court, they'll have what's called a detention hearing. Basically, this is like a first appearance or initial appearance. It can be 24 to 48 hours after they've been picked up. It can be a little bit longer if they get picked up on a Friday. So if a juvenile were to get picked up on a Friday, it's very possible they won't go in front of a judge for up to 72 hours, if not a little bit longer, depending on what time juvenile court is. But again, it depends on the jurisdiction and how the rules of court procedures are held. But it can include prosecutorial decisions, can also include diversion, keeping low risk and low level offenders from entering the system. And it can include adjudication, which ensures that the juvenile's due process rights have not been violated. And we talked about how this is like the trial in the adult criminal justice system. Once they are given a sentencing or they go to sentencing, they'll have what's called disposition. That's simply where the judge will sentence the juvenile delinquent. And dispositions can include probation, boot camps, and even committing them, or commitment, which is incarceration. Now, another step is called intake. Intake is just where you get a group of individuals who may simply dismiss the case or defer the juvenile from court and into diversion, or they may file a full-blown petition. Now, the intake process is a very powerful process depending on the jurisdiction. If what I'm saying is very true, and it is, because we had an intake department, we had a supervision department. I was in the supervision department. The intake department, they had the power to make referrals and in some cases dismiss cases outright, meaning that juvenile will be free. If they weren't sure, they would send it to the state attorney's office and let them figure it out, or district attorney's office. But yeah, it's a very important aspect of the juvenile court process because of the power that intake wields. And then we have what's called teen court. And so before you get distracted by that handsome young fella right there, that was me a long time ago. Teen courts are diversion programs in which the punishment is handed out by a jury of the youth's peers. It's very unique because it's the only part of the juvenile justice system where a young person is punishing another young person for a delinquent act that they've committed. It is very unique. And so what it does is it allows youths and teenagers to give out sanctions for those other youth who've broken the law or have committed a delinquent act. Now, what's beneficial about teen court? Well, one, it offers accountability. The individual has to take accountability and recognize that they did something wrong and they should be held responsible. It offers timeliness. Typically, with teen court cases, they're heard within anywhere from 14 days to a little bit shorter, whereas a regular juvenile justice delinquency case can take several months before anyone goes in front of the judge. Again, I talked about timeliness, cost savings. It's a lot cheaper to send someone to teen court where, only $3 per day is going towards the funding of the program. The young person is not usually having to pay anything, but it does save us a lot of money. And then lastly, the community cohesion, because many adults want to be involved in teen court. In fact, generally speaking, if they don't volunteer, we have two key models, which helps to, determine how the teen court proceeding is going to be held. The first is you have the adult judge model, and that's where you have an adult who's typically an attorney or they're an actual judge. They will sit and preside over the teen court hearing in a ceremonial role. So they're not sitting there as like, oh, as your judge, case dismissed. No. Or as an attorney, I find that this case is really bogus. This person should not be in teen court. No. They're there as in a ceremonial role, but yet they are deciding what the punishment is going to be, at least in terms of what other sanctions may remain. And those other sanctions can include apologizing, writing an essay, showing that you are going to practice remorse, etc. Now, the peer jury model, and this is the one I really enjoy, this is where you have teens under the age of 18. They sit on a jury, they render the verdict, and they provide the punishment. So you're not getting it from the judge, you're getting it from other kids. And so these kids can say you got to do community service, you have to do drug screens, you have to go ahead and do counseling, like all those. And whatever those kids or those teens or those peer jury members say, that is what the individual will have to complete in order to successfully get out of teen court. So yeah, teen courts are very, very effective models, whether you have the adult judge model or you have the peer jury model. It's a very effective program. I really wish I could have brought it, to my jurisdiction in Georgia. I was unsuccessful, but I believe it's a very beneficial program, and it gives kids an easy way to learn about the law, learn about the court system, and just recognize that the juvenile justice system is more than just some adults, or the juvenile justice system is more than just some kids, rather, who are just in trouble and that's it. There are other branches of the system, which includes the diversion side of things, which is trying to keep them from getting into any more trouble. So in a concluding thought, and I thought I would end this lecture in a very unique way, how should the juvenile justice system handle situations like this? Now, what you're seeing right here is this young lady is 6 years old. She was a 6-year-old girl who was arrested in Orlando. She was taken into custody because she threw a tantrum in her classroom. She threw a tantrum, and the Orlando Police Department took her into custody. They arrested her, and the case got significant national attention because she was, one, charged with misdemeanor battery, but two, because she's 6 years old, right? 6 years old should never be taken into custody. You should never have a situation where a 6-year-old is finding himself detained. So since this happened, and this was back in 2018, somewhere around there, the family has filed lawsuits, and they've expressed how the young 6-year-old has been traumatized. She has dealt with significant distress, and the argument is that there should never be anyone under 6 years old getting detained. So in 2021, a law goes into effect. It prohibits a child younger than 7 years old from being detained with a violation of a law unless it's a forcible felony. And a forcible felony would be like a sexually assault-based felony. But in terms of data, when you look at the 2022 data, or maybe 2023, the Florida Department of Juvenile Justice said 2,085 children under the age of 12 were detained in the Florida fiscal year. So kids under 12 are getting locked up, whether they're getting locked up justly or unjustly. it is very important to understand that this is going to breed controversy. Should we be detaining 6-year-olds because they threw a temper tantrum? Should our school resource deputies be treated like candy shops because now they're at the disposal of the administrators? You be the judge. You be the judge. It'll be interesting to see if the family did settle their lawsuit. But it's definitely eye-opening when you have a 6-year-old, 7-year-old, young child getting detained because they threw a tantrum in class. So I want to thank you for listening, tuning in to the juvenile justice system. When you hear me one more time, it'll be our final chapter focusing on other contemporary issues within the criminal justice system. But thank you for tuning in, and I will see you next time.